wishes to thank Mr. Wallison for his testimony today, and Mr. Wallison, you are now excused from the panel. The chair now recognizes the gentleman from Ohio, Mr. Davidson.
Thank you, Mr. Chairman, and Mr. Wallison, thank you for being here. Thanks for the things that you've addressed with the FSB, and particularly the short changes they've done on American sovereignty. So that's of particular concern. I have enough questions for other folks, so thanks for being here. And really, thank you all. I've learned a lot and reaffirmed many things that I have already learned about the impact of Dodd-Frank, both from your testimony today and from your prior work, so thank you for Mr. Allison, in particular. I appreciate your clarity, both here in your books, in your work at Cato, and you all have sounded the alarm for some of the misses and perhaps unintended consequences of Dodd-Frank. While I have myriad concerns about the negative impact on families, farms, and businesses, I am particularly concerned about due process. These protections are some of the most important in our Bill of Rights. And Ms. Pierce, you've talked a fair bit about some of those concerns with respect to the SEC. Under Dodd-Frank, do respondents in SEC administrative proceedings have the same rights as defendants do in federal district court?
No, the two systems are different, and some have argued that there are some issues with the administrative proceedings and have called on the SEC to make changes. I don't think the SEC has made enough changes yet to equal out the two.
Does the mismatch create the potential for different legal interpretations of the same or similar laws and potentially create inconsistent enforcement outcomes?
It does. There's a potential that you could get different outcomes depending on which forum you were in.
Do you believe that a respondent can receive a fair outcome when the SEC serves as prosecutor, judge, jury, and many times ultimately the appellate body?
I think that the SEC can run its system well. I think it will run it better if people have the option of going to court if they prefer, which is what the Choice Act would allow.
Thank you for that. And I just wanted to open up to the panel just some of the concerns that you may have with respect to due process that you've seen as a consequence of the Dodd-Frank changes.
I think one general thing is that any regulated company, particularly now, really doesn't have practical access to the court system, because the time the courts decide, you're already out of business. And under the doctrine the court has, they think the regulator's right, and you have to prove the regulator. It's like being assumed guilty, and you have to prove you're innocent, and that is very hard to do.
This is fundamentally a consequence of Chevron doctrine.
Yes.
Yeah.
You know, a lot of the regulation is not even being done through rules that could be challenged in court. It's being done through supervision, which is it's a big problem in the bank regulation side.
I think if you look, by contrast, at the way in which the court system has actually gotten involved in Dodd-Frank compliance issues, it's been quite extensive. I mean, the fact of the matter is, in the PHH against CFPB case, which is challenging its constitutionality, that is a case involving whether the CFPB followed proper procedure with respect to its internal operations, and the courts seem quite aggressive about enforcing that. I think you can see it in the MetLife case. You can see it in the cases brought against the SEC. So
I want to highlight that this is pretty
active.
late in the game and fairly consequential. If you look at PHH, look at the valuation of their company and what happened to, they've been decimated basically by fiat.
I think if you look at the way in which the court system is overseeing agencies, it's been quite active.
Ms. Pierce, would you please?
So I would say that, you know, it's fine to cite PHH and MetLife, but those are the two companies that were able to fight because they had the resources and the courage to do so, but often it's just not worth the regulatory risk to take the fight to court. So you just suffer with the consequences.
Thank you for pointing that out. I think we're at about a 90% conviction rate, which is, you know, a little shocking. It basically says, yeah, cave or else. Dr. Michelle, you were going to say something.
I was just going to add ally to that equation. It's an example of just kind of giving up and going ahead. You have no reason. You have no contact with the borrower at all, and you're accused of racial discrimination, and you know that the race of the borrower was never even...
particularly when automotive lenders were explicitly excluded.
Carved out, and you still find yourself with the choice of going to court or just settling to get this over with.
Thank you all. Mr. Chairman, I yield back.
Gentleman yields back. Chair now recognizes the gentleman from